SJC-12076, Commonwealth v. Alberto Martinez.
Good afternoon. Is it Ms. Dame or Ms. Dom?
Dame.
Dame. Okay, you may proceed.
Thank you. Michelle Dame for Alberto Martinez. Today I'm asking you to reverse Mr. Martinez's conviction for one reason. The motion to suppress should have been allowed as the IP address alone did not provide a sufficient nexus between child pornography and 231 Sunset Hill. In this case, investigators downloaded files containing child pornography from a specific IP address, and through a subpoena, they were able to learn that the subscriber to that IP address was Angel Martinez, and the residence associated with that was 231 Sunset Hill in Fall River. A couple of weeks later, a police officer went to 231 Sunset Hill, saw that it was part of a housing development, and learned that Maria Aviles lived there, who was the mother of Angel. The only thing that linked 231 Sunset Hill to child pornography was this IP address.
But the IP address is pretty unique, isn't it?
An IP address identifies a single computer, but that computer might be...
Identify a single computer. It identifies a
Router.
router.
It identifies a router, yes. And the Wi-Fi radio signals originate from that router if it's a wireless network.
Be numerous computers.
Could be numerous computers and in numerous locations. The radio signals can transmit to approximately 300 feet, and they can go through buildings. So that essentially means that anyone that has a computer, cell phone, tablet, any device that can connect to the internet could be accessing that network even if they are in a neighboring house.
So what does that mean? It means that at least that address, that physical address that the internet service provider says is associated with that IP address at that particular time would be a place to look, right?
It means that the child pornography is associated with the IP address, but not necessarily that it's associated to any device that's located in the residence. It could be someone who could be found on a device, someone that's been accessing the IP.
For probable cause.
The test of probable cause is whether the facts in the affidavit, along with reasonable inferences, are sufficient to conclude that the facts sought are related to the criminal investigation, and that they may reasonably be expected to be located in the place to be searched at the time the warrant issues. But I would argue that computers are a very personal and private object for most people. They contain not only potentially legal secrets on there, but also potentially embarrassing secrets. Because of that, I think that more investigation needs to be done to try to corroborate that the child pornography would likely be found in the subscribing residence as opposed to an alternative location. For example, in the 6th, 3rd, 8th, 5th circuits, as well as federal courts in Nevada and Oregon, the investigators actually confirmed that the subscriber lived at the residence associated with that IP address.
Subscriber's not relevant. I mean, it doesn't have to be the subscriber whose computer is being used.
I think the subscriber is relevant. The subscriber is the one who's in control or more in possession of the network, and it's likely that they would know the password to the network if it was password protected. So, for example,
didn't the subscriber live in this address?
the subscriber did not live at the address in this case, and there was no evidence that he actually did.
Mother did.
His mother did. But for example, he could have been living at a neighboring house, and if that was the case, it's very likely that he was accessing the network from that neighboring house, and therefore that the child pornography could be found at that location. If the investigation did reveal that he lived in another state or another country, then obviously that wouldn't be relevant. The fact is that no investigation was done in this case to confirm where he lived. What we do know is that the two targets of the search warrant were Angel Martinez and Maria Aviles. We also know that the investigators had reason to believe that the downloader of the child pornography was male, given the screen name that was used. However, there is no indication that Angel Martinez lived at 231 Sunset Hill or that any male lived at 231 Sunset Hill. And I think that's extremely problematic when they believed that a male was the one who was doing the downloading. There's always the danger that the person who has subscribed to an IP address no longer resides at that residence and resides elsewhere. The Second Circuit did address this concern, and while they stated that that may not necessarily invalidate a warrant, this is only when the current resident continues to pay for the services and has simply neglected to change the account holder's name. There is no information in this case that Maria Aviles was the one who was paying for the internet and had simply neglected to change the account out of her son's name.
But I mean, how recent was how long was the search conducted after they identified the IP address?
They went to the location approximately 2 weeks
So.
after they got the
Okay,
information.
so 2 weeks after they say that the router for this child porn is a router that is subscribed to Angel Martinez at 231 Sunset Hill, they then do a search at 231 Sunset Hill. Now, you're saying that potentially the person who was doing the child porn it might have been unsecured, and it could have been a neighbor who could have gained access, but isn't that merely a possibility?
It is a possibility, but given the privacy protections that should be afforded to the home and to computers, I think it's one that should be explored. The Fifth Circuit.
And how would they explore it? How would they know whether or not there's an encryption with regard to that router?
Well, one of the ways that the officers could have done this is they already went to 231 Sunset Hill that's how they learned that Maria Aviles lived there. What they could have done when they were there is pull out a cell phone. On your cell phone, you can search for wireless networks in the area. From there, they could have tried to pinpoint which network belonged to 231 Sunset Hill, whether it was password protected or whether it was not password protected, and from which other residences in that area could have been accessing the network. In a Sixth Circuit case, United States v. Hay, another thing the investigators did is they placed an undercover phone call to the defendant, and that was how they were able to gain more information about the setup of his computer, and that's how they gained more information to get probable cause to search his residence in that case. The Fifth Circuit did address the concern that there may be outside people at outside residences accessing the network. However, they improperly compared an internet connection to a screen name. A screen name is always password protected, whereas an internet connection may not be, especially when you're dealing with close-knit residences that are likely sharing an internet connection. And you're not going to give your password to your screen name to anyone. It contains personal, private information like an email, but you may give your password to your internet connection to neighbors, to other people in order to share internet access.
What are you saying? Explain again what you think the police should have done here.
They could have gone to the location, as they already did, and then taken out a cell phone. And when you're on your cell phone, you can search for wireless connections that are in the area, and from there they could have tried to pinpoint which of those connections was associated with 231 Sunset Hill.
And you're saying it would have identified the router, and it would have said that it's available to the public or that you need a password?
Correct.
And if it was available to the public, then what would follow from that?
They could have figured out the proximity, which residences would have been able to access that network, maybe done a little bit more investigating as to who lived there and whether it was probable that one of those people was actually connected to the child pornography. Or maybe if they were, for example, if Angel Martinez lived in one of the neighboring houses and it was password protected, then they might have had reason to believe that it would actually be located in his house, as opposed to 231 Sunset Hill.
But he was the subscriber. I mean,
He was a
he's the one
subscriber.
paying Verizon or whatever for the router, so.
He may not necessarily be living at 231 Sunset Hill. There was no evidence that he was.
But if he's stealing, if it's not password protected and he's stealing it, why would he be the subscriber?
If it was password protected and he lived next door, if he lived next door to his mother, but he paid for internet services and was using the internet from his house next door, if that was what was going on.
I guess I'm having trouble understanding why that just doesn't expand the field in which the authorities could search. I mean, because then there'd be probable cause to search within the radius, wouldn't there?
I think there needs to be more of a specific location and pinpoint which residence is more likely to be containing this child pornography.
I think what we're asking you is if you do what you ask and you're in an urban area and you pull up your cell phone and you get 6 different wireless networks, you're saying they should search all 6 as opposed to the one that's standing in?
I'm so sure that's where maybe an undercover phone call like they did in United States v. Hay could be important to gain some more information about which residence is involved in this case.
And the undercover phone call would be to whom?
would be to Maria Vilas or Angel Martinez, the one who's a subscriber or living in the address.
Say, do you have child porn on your phone? I mean,
Not pornography. In United States v. Hay, when they placed the undercover phone call, they were able to learn that there was only one computer in the residence and that it wasn't shared with anyone else and that he was actually the only one that accessed the network. And from there, they went and they searched the residence.
Well, this case is different from the last one that we had. You had 5 different people living in one apartment, apparently, or maybe 2 apartments. I mean, here, it doesn't appear that this suspicion could be dispersed among a wide variety of people. We've just got this one party here. So why isn't that sufficiently specific and particular to support probable cause? Why isn't that good enough?
Because the only person that they did warn that lived there was Maria Vilas, and the investigators did not believe that it was a female that was downloading the child pornography. They thought it was a male, but never confirmed that a male lived in the
But
house.
that doesn't really detract from probable cause, does it? I mean,
If they had probable cause to believe that a male was doing the downloading of the child pornography, but they didn't have probable cause to believe that a male lived in 231 Sunset Hill, then I think that is a problem.
You say they had they knew it was a male because there was some name given to it that was male?
The screen name was Datfly Poppy, and that would have been indicative that it was a male who was doing it.
And which part of Dat Fly Poppy makes it male as opposed to female?
The PAPI, Poppy, would be referring to a male.
Well, I knew that Big Poppy would somehow come up during the course of this day during playoff
he's been
season.
waiting for it.
Okay.
It is possible that an IP address may not be part of a wireless network, or if it is, that it is password protected. But there is also the possibility that we are dealing with an unprotected wireless network, and it's not unreasonable to expect officers to take some steps to confirm or dispel this. I would argue it's similar to the rule that this court announced in Commonwealth v. Canning and last April, which said that when there's probable cause to believe that marijuana is being grown in a home, it's possible that the person is registered to do so, and the officers need to take some steps in investigating this. The statistics the Commonwealth cites to in its brief do show that at the time that the search warrant was issued, that more wireless networks were password protected than weren't. But I would also argue that it's probably true that more people are not authorized to grow marijuana in their home than are. But still, they need to do some investigating in order to find that out before a search warrant can issue, and I suggest the same should be done in these circumstances.
but that's because it's possible that the conduct could be legal, but in this case, child pornography, there's no possibility.
Some
that that can be-
possibility it's legal, but there is the possibility that it's not actually occurring in the residence in which you are going into and seizing and searching any number of computers that are in there, which again are very private and personal information are contained on computers. A lot of secrets that could be very, very embarrassing and very damaging for people that if they were to come out, that could also be legal as well. The Commonwealth also tries to argue that if a person doesn't password protect their network, then they somehow lose the privacy interest in their home. And I would argue that this simply does not make sense where the utmost privacy protections have been afforded to the home and to computers inside that home. If you allow a person into your home and unknowing to you they leave contraband behind when they leave your house, the officers still need to meet the standard of probable cause before a search warrant can issue and they can go in and search your house. And so just because you leave your network open to other people to use does not mean you somehow lose a privacy interest in your residence. I'm not trying to suggest that the police need a guarantee that no one else could be accessing the network, but I think it's reasonable to expect them to do some investigating and to outline the steps that they took in their investigation in their affidavit as to what type of connection is involved, whether it's wireless, whether it has a password, whether it doesn't have a password, what steps they took to try to figure out where the subscriber lives, if they actually live in the residence, if they live around the residence, or if they don't even live in the area anymore.
So if the subscriber doesn't live in the area anymore, so what?
Then it means that then it would be more likely that it is actually being found in the residence if the subscriber is no longer there.
Then that
If the subscriber is not even anywhere around and the subscriber could actually not be accessing the network, then I think it would make the argument, it would be more likely to be found in the subscribing residence. It would probably be then the case where the person that actually lives at the residence pays for the bills and just simply never change the account out of the name.
So the IP address is a mailing address?
The IP address is not, but it's linked to a mailing address.
I thought that the IP address was linked physically to a physical location, that being where the computer
It's where the router would be located,
router is.
where the router is.
So you're saying that the router of a subscriber would be at a far distance?
The router would be inside the residence, but doesn't mean the subscriber lives there anymore.
And so what difference would it make if the subscriber does or does not live there anymore? Isn't the question where the router is?
It's not the question where the router is, it's a question of where, not a question of where the router is, it's a question of where the child pornography would likely be found and where, so who is doing the downloading and where does that person live? It's more more need to find out about who is actually doing the downloading.
Okay, thank you.
Thank you.
Ms. Stern, good afternoon.
Good afternoon, Your Honor. Shoshana Stern for the Commonwealth. As a preliminary matter, I think possibly a useful distinction in this case and the one before it, I think there's a question of what happens when you run the facts of the case through the probable cause analysis versus are we comfortable as a society with where that takes us given the technology. I think that the issue raised here, I mean, the defendant's motion to suppress was essentially, he actually says, technology has changed things, but all that is required here is the establishment of the four corners of the affidavit under a probable cause analysis. I would argue, as we argue in our brief, that there was, under the probable cause analysis of reasonable evidence of the thing to be searched for and the place to be searched, there were a number of different things that could be reasonably expected to be in the home, in particular the router itself, which I would argue is less probable that the person the person accessing the computer did not at least spend a considerable period of time in the house. The router is still there. Frankly, even if the router was a front for somebody trying to disguise their identity from somewhere else the router is still there. The router would still be documenting who had contacted it.
So does it have any connection to the billing address? I mean, I'm not seeing what the connection is with the subscriber. And I mean, it's the IP address where the router is, right?
That would be my understanding, Your Honor. It's the router, the modem, some combination, but it's the physical address where I believe the internet service provider provides the internet to you.
And that's what makes the IP address somewhat unique.
Yes, I think if you take your router somewhere else, you will have to get another IP address from whatever the source of the internet there is, unless you arrange. So it's essentially the location for practical purposes. I think you can get a little bit more arcane, but it's the location at which your service provider is providing your service. And when the police send them an IP and say who was using this on March 9th at X hours, they can say this is who we assigned it to. They give it to you. Your computer, I think, essentially asks them for an IP address, and they assign you one for your use at that time. So they would be in a position to know that that is where they were delivering the internet to that IP address.
It is. So the IP address seems to be somewhat time-specific, right? I mean, you could have a different IP address assigned to you in February than you did in November, right?
Conceivably, you might not.
Well, why would that be true?
My understanding is that for various reasons, the service provider owns a number of IP addresses, and they might assign different ones to different places at different, not necessarily for a reason, but just that they're.
But isn't it unique to me?
It's unique to you at that time. At the time, the ISP will, for at least a duration of time, assign you an IP, which is what you have at that time. They may then another day assign you a different one, and in all those cases, it's I don't know the technical details about how people then know how to find you. They know what they have done, is my understanding, and they have records of this. I don't know what their reasons are for changing them. It might be security. I think if you always have a single IP address, it might open you up to vulnerabilities.
I might have an IP address in November. And somebody asks in January what what this IP address was, is. And it can be given for some period. So I'm getting to the staleness thing. I mean, if you don't go soon enough, it might be that the location isn't really necessarily tied to the IP address.
Well, I think the question is what question you ask of the service provider in the administrative subpoena. If you say who had it on March 9th, and they say on our records on March 9th, we gave this
Yes.
this IP to
But
this
if
address.
it's June and you're doing that, I mean, what good does it do you who had it on March 9th?
Well, if you got the
You want to go there now.
if you got the IP in June, but if the IP was at this address on March 9th, that address is still there and that service is still being provided by the service provider. The fact that they have now given the IP to somebody else does not change the fact that at the time the IP was involved in transmitting child porn, it was at this address.
But
But the computer might not be there anymore. The router might not be there anymore.
Well, I mean, I think that they can say that they're still if they're still providing service to that address. I mean, they have these records. They would know at least if I mean, again, the subscriber doesn't matter as a person, but as an account, I think they could say, there's somebody completely different now. I mean, I think that as with staleness, that's all, in this case, it was all within a month.
All right. But I'm just trying to
but-
draw it out.
But I think that that is something that the ISP would be in a good position to provide fairly detailed information about. Again, it might not be the same. I mean, if I get a different phone number from my from my cell phone, but it's still the same provider who's giving it to me. Let's say I move, and for some reason, even though nobody does that anymore, I get a new number. They can still say, we've been providing the same service consistently to this person. It's not the number. They know what my phone number was. They know what my phone number is. They know where they bill me. I mean, it's not as physically fixed in the same way as the ISP, because not only do they bill at that address, they provide the internet to that address, and you
so
can't take it with you.
But do administrative subpoenas really ask all those questions?
I think it would depend on. I mean, I don't know that they always do. If you thought, I don't know that they need to, but if you had a very large span of time, there might be, if you're trying to figure out for some reason who had this address. I don't know how long they keep the data. I don't know if you can say, if I could say now who had this on March 9th.
We don't have a staleness challenge in this case.
No, Your Honor. I mean, I as always with any sort of somewhat novel area of law, I suppose it has the potential to arise. But I think in this case, they asked Comcast. Comcast said this is who had this IP at that time that the IP was transmitting. This is the place that had the IP. And as the author of the affidavit says in I think one of the appendices, essentially what happened here was the digital equivalent of knocking on a door and asking if you can have some drugs, and someone hands them to you. You may not know who they are. You may not see the person. You may not know how many people are in the house. But at that point the drugs are being dealt out of the house.
Well, but I mean, Ms. Dame is correct. There's at least a possibility that if it's not a secured network, somebody nearby could gain access to it and then use it and not be in that apartment.
There is a possibility. I would disagree with my sister's reading of the federal cases. I think that in general, they and at least a number of state courts feel that that's not a sufficiently high risk to defeat probable cause.
But I guess the question that I would be asking, going back to the last argument, is it something that is part of a minimization protocol one would want to make sure to protect against? Before you begin, one thing with regard to the seizure of the computers, but before you begin to do your examination of the computers, should you at least explore that possibility?
Well, I think that, first of all, I think it's still, as we argue in our brief, it's no easy thing to figure out if you can figure it out at all before you go into the house. Once you're there, I mean, I don't think, as we argue, first of all, you could defeat all searches by having an unsecured wireless network if that were a defense against being searched at all.
No, I understand it may not be a defense against the search, but
yes.
it may be relevant to how many people may have had access to that router if it was not secured, and therefore may affect the likelihood that the computers you seized in the house may contain the child porn.
I mean, I think that it's not, In terms of producing minimization policies, I have a certain concern that, it is very technical. I would want to see sort of authoritative answers from a technical perspective. I've tried to do research on this, but Justice Hines had a question about, should we take the police's word for what they can and cannot do? Let's say we don't take their word. I think that it would need to have sort of some sort of there was no evidentiary hearing in this case. There was no discussion of the realm of the possible. I think it's hard for me as a lawyer, even one who's tried to do her homework, to sort of discuss what really is and isn't feasible from a
Right.
non-interested
But I
party.
guess the
'Cause
question is not so much should we, as a court, attempt to identify what the protocol should be, but should we say that there should be
Yeah.
reasonable minimization protocols and then let the parties determine whether or not what was done was reasonable?
I think that, I don't know if this is in particular a good vehicle, whether the figuring out, how open was the Wi-Fi is necessarily the sort of place I would put that, partly because downloading videos with Wi-Fi that goes through walls, frankly, is not usually that easy. It could happen, but I think that in those cases, there's a strong likelihood that something that uses that sort of bandwidth is taking place inside or very close to the residence. But on the subject of, the warrants in this case lays out some very detailed reasons why, as a practical matter, you have to potentially conduct extremely in-depth searches. And again, that comes back to the question of not as a probable cause, but are we okay with that? I think that would sort of be the question of, is there a way to protect? I mean, I've heard from a number of sources that it's very difficult to limit what you look for as a technical matter when you're doing a forensic search of a computer, in which case the only other option would be to limit what you're allowed to have found, and some sort of taint team response. That's just sort of me thinking off the top of my head. Certainly, there must be a way to reconcile sort of what we want the expectation of privacy to be and what the technical components are. I would again say that it's extremely important to make sure that there's a maximum understanding of the technical aspects before making any such determinations, just because, and particularly because those change faster frequently than the law, but that it's important whatever ultimately ends up happening. I know, as Justice Lank wrote in Dorless, that, this might not be the day to discuss this, but eventually that's coming. But I would say that when it comes, it just needs to be made on as sound a technological background as possible, because those are just very, very specific matters. And again, whose authority you take for it. I think that it's somewhat of an expert matter, and it's important to get it right in terms of how things actually work. There are no further questions. The Commonwealth rests on its brief.
Thank you.
Thank you.